Thank you, my lords and my ladies. I shall be arguing three main points. One is the issue of whether the matter for nomination is ripe for determination by this honorable court. Number two, I'll be addressing the retrospective aspect of the Mativo judgment. And I'll also address on whether the withdrawal of one of the candidates had any effect of cancelling the 26th of October elections. My lords and my ladies, as far as we are concerned, the issue of nomination of presidential candidates is water under the bridge. That matter has been fully settled by a court of competent jurisdiction, being High Court Petition number 471 of 2017. My lords, like my learned friend has said, the High Court did not just assume that jurisdiction. It actually acted on directions of this honorable court to interpret Article 138 and 140 on the meaning and effect of fresh elections and who is eligible to participate in the fresh elections. Suffice to note, that judgment has been appealed against in Court of Appeal number 359 of 2017. We have annexed the memorandum of appeal for this court to consider. That appeal is still pending. My lords, if a matter is pending before a court of appeal, can this honorable court litigate and make a determination on that issue, which is still pending and active before another court? The answer should be to the negative. In your advisory opinion number 2 of 2011, the court clearly stated that where there is a matter that is pending before another court, it does not necessarily mean that this court has no jurisdiction, but to respect the rule of law, it is always good for this court to allow all the other processes to take place so that it might end up here in the right way. Based on that submission, we submit that this court should exercise restraint in addressing and making a determination on a matter that is actively pending before a court of competent jurisdiction. I refer you to our list of authorities at page 57, paragraph 72, for that observation by this honorable court. My lords and my ladies, during the Mativo judgment, the issues before that court were premised on violations of human rights and fundamental freedoms. The High Court exercised its jurisdiction under Article 165 and made determinations. Now the question would be, did that judgment have any retrospective aspect that would have cured the events that took place a day before the judgment was delivered? The answer is in the affirmative again. My lords, Article 19 is very clear that fundamental rights belong to every person. They are not granted by the state. That would mean Justice Mativo did not grant the right to participate in the election to my client. That right existed even before that judgment was delivered. Therefore, whether one candidate had withdrawn before the date of judgment would not have affected the right of my client to participate as a candidate in the 26th October elections. My lords, this is not just an argument by myself. This court has made that determination before. In our list of authorities, we have annexed an authority the Mary Wambui case, where the court says, and allow me to read for emphasis, judicial decisions which set a precedent in law do have retrospective effect. First of all, the case which decides the point applies in retrospectivity in the case being decided, because obviously the wrong being remedied occurred before the case was brought before court. Therefore, the right to participate, or rather, the wrong that was occasioned by the first and second respondent did not occur on 11th when the judgment was delivered. That wrong was occasioned way before that day. It was not upon the court to confer that right. The court merely exercised its right, rather its powers, to declare that right existed and was violated. So in my humble submission, my lords and my ladies, yes, the decision to withdraw occurred a day before the judgment, but that had no legal effect that would have in any way affected the rights of my client under Article 38. My lords, allow me move to the elephant in the room, but before I do that, when you read the Mativo judgment, and I really request the court to read that judgment in totality, it was not just because my client's rights were violated under Article 38. It was also premised on interpretation of this court's decision in the Raila case, where the court said that if one of the candidates is a petitioner and the petition is successful, then that party will be entitled to participate in the election. Now, my client applied to be enjoined as an interested party in these proceedings in support of the petition. When you look at your ruling in the Muruateto case, which we have annexed in our list of authorities, he acquired party status. The benefit that was to be accorded to the petitioner is the same benefit that ought to be accorded to an interested party who opposes that petition. So if then the petitioner had a right to participate by virtue of being a successful petitioner, then an interested party who supported the petition will also benefit as such a petitioner. My lords, I can say I have 15 minutes, and I had promised the Honorable Attorney General to grant 5 minutes of my time. I intend to keep that promise. I'm hoping that my client will not slash part of my fees because of the 5 minutes. My lords and my ladies, on the issue of nominations, so if this court is then persuaded that it can make a determination on the issue of nominations, we have the following submissions to make. Number one, this court has rightly pointed out that an election is a process. So then the court would ask itself, where does that process begin and where does it end? When you look at Article 136, the stage is set for a presidential election. But we have no players in that election. Therefore, there are other processes that ensue to complete that process, which ultimately ends at Article 141 when the president-elect is sworn into office. So the court must look at it that way. So the process of nomination then is merely an exercise to identify eligible candidates to participate in an election. The articles that go after 136 are articles that are meant to give effect to that important exercise under 136. So the question that this court will be asking itself is, were the candidates identified? Were they existing by the time we were going back to the repeat poll? The answer again must be in the affirmative. Now, my lords and my ladies, some of the processes that occur before the actual casting of the ballot are exhausted and completed. I would use the word sealed and preserved. One of those processes is voter registration. Inspection of the voters' register. It would bring a very absurd meaning and make it impractical to go back to a repeat poll based on the argument by the petitioners that once you invalidate an election, then all the other processes are also spent or expired, so to use their words. Would it also mean that we go back and register voters? Would it also mean that we go back and inspect or publish the register? Because nomination is not the only exercise here that precedes the casting of the ballot. There are other processes. And if you tell parties that nomination is a requirement, there are other processes that precede the actual nomination by IBC, including compliance with the Political Parties Act of submitting names of members of those parties. So can you do that within 60 days? Again, the answer is in the negative. My lords, we have situations under Article 138 and 139, and this goes direct to answer the question that the learned Judge Renaula asked yesterday. What happens under Article 139? The doctrine of necessity kicks in because we do not have a candidate. That candidate does not exist. And 139 is where we have concluded the process, a president-elect has been identified, but then he dies. So as of necessity, we have to go back and identify another candidate to replace the president-elect. My submissions again is that if we talk about nomination as a process that must be done after an invalidation of the election, then we'll bring absurdity in that application. My lords, let me move to the very last part of my submissions, and this entails my client's interaction with the electoral process. My lords, like my learned senior said, we can never have a perfect election. It is bound to have shortcomings, but if we prove that those shortcomings were addressed adequately, then there is no need to nullify the election. My client is one of those voters who could not be identified through the KIMS kit. And this is a question that was brought about yesterday, and he has put that in his affidavit. He appeared in a polling station, and his fingers could not be read by the KIMS kit. He's not a very elderly member of the society, but for one reason or the other, his fingers could not be traced. And that goes to what my learned friend, Mr. Mahat, was saying, that they had put in place systems to ensure that the process runs smoothly. So his ID was taken, and alphanumerically, he was identified and allowed to vote. That confirms what the IBC was saying, that they had put in place mechanisms to ensure, or rather to mitigate, the instances that led to the nullification of the 8th of August election. My lords and my ladies, to conclude, I wish to state that the petition before this court is about the 26th of October election. It is not the previous election that was held on 8th of October, because we are likely to drag the issues of the previous petition into this petition. The court should look at IBC and ask itself, after we gave our order of 21st, or rather 1st of September 2017, what was complied with. And when you look at the affidavit sworn by Dr. Ekuru Aukot, he has annexed a comprehensive report indicating the failures that were identified as a result of this court's judgment, the law that is applicable, and the mitigating measures that were put in place to ensure that we have sealed those loopholes. I urge this court to look at those, that affidavit and compare that with the submissions made by my learned friends here, and it will arrive at one conclusion, that IBC conducted this election in a manner that is in compliance with the laws and the constitution of our country. I wish to associate myself with the submissions made by my learned senior, Mr. Ngatia. He made a fantastic job in analyzing the Raila 2013 case and the Mativo judgment, which settled the issue of nomination. I could not have done a better job than he did. I rest my case.